go on our website after the meeting is resolved. I'm gonna start with a short introduction, and I'm gonna throw it to the hearing officer. Does anybody have any questions before I begin? Okay, so it's
You're good.
we'll go ahead and record.
One moment, please. So Aaron, this doesn't have to be on the record. I will let you know when we go on the record and when we go off
sure.
the record.
Okay, yep, sure, go ahead then.
Okay, but you can hear fine and then Aaron?
I can hear fine. Can you hear me fine?
Yep. Perfect.
Okay, great, thank you.
All right, thank you, Aaron. I appreciate it.
Okay, good morning, everyone. Welcome to this meeting of the Crane Operators Examining Board. Today is September 5th, 2024, and the time is now 9:47. Before we begin, I have some important ground rules. For those joining us remotely, you should remain muted except when required to speak. Board members today are joining this meeting from 3 locations connected by video conferencing in Albany, Syracuse, and White Plains. I will note one of the board members is not yet at the White Plains location. He is listening to this to the start of this meeting, and he will join the meeting as a board member once he arrives. Today's meeting is an open public meeting and is being recorded. The recording will be available on the Department of Labor's website for this board. You can find more details on the work of the Crane Operators Examining Board there as well. I will now call a roll of the board members to establish a quorum. Terry Hogle. Here. John Dillon. John, are you here? John, are you? I can see you. Are you present? Can you unmute yourself? Jeff, can you? I know. Can you please mute yourself?
Mhm.
John, we don't quite have audio on you.
They left and then came back in.
Okay. Reestablishing audio with Syracuse location. Okay, we have you back, John.
Present.
You here? Okay. Jeff, although you are available and listening, you're not currently present as a member of this board. And Vince Rapicciolo is me, and I'm here in Albany. So we do have 3 of the 4 current members of the Crane Examining. Do have 3 of the 4 members of the Crane Examining Board present in public locations, so we do have a quorum. So Jeff, you can go ahead and mute.
Yes, Vince, I've been muted, but hopefully you can hear me now.
Okay, okay, we can hear you, and know that you can't speak in the meeting until we do get you to the White Plains location. There is a quorum established. There's only one item before the board today, and that's a hearing on the matter of Trevor S. Hange. And for conduct of that hearing, I'll turn it over to the hearing officer, Tracy Simmons.
Thank you. So Aaron, we can go on the record now. All right, so I call this are we on the record, Aaron?
Yes, I'm sorry, on the record, time is 9:51 a.m.
Perfect. All right. I call this matter to order. We are on the record, and I will note as well, the time is 9:51 a.m., Thursday, September 5th, 2024. This is an administrative hearing in the matter of suspension, revocation, restriction for a crane operating certificate of confidence relative to Trevor Hangy, crane certificate number 19-0038, the respondent in this matter. A panel from the members of the Crane Board Operator Examining Board has been designated to conduct this hearing. This panel is comprised of Terry Hogle, John Dillon, Vincent Rappaciulo, and we will be adding a fourth member, Jeff Laughlin, later. My name is Tracy Semix. I am the hearing officer with the Administrative and Adjudication Office for the New York State Department of Labor. I will be moderating this hearing to facilitate the procedural aspects of this proceeding. I am not a voting member of the hearing panel. This hearing is brought on by the Department of Labor to inquire and report to the Commission of Labor whether Trevor Hangy's involvement in conduct to report an incident/fatality as an unusual incident and whether to suspend or revoke or restrict the crane operator certificate of confidence. So in particular, the examining board will determine whether you violated a regulation or law, whether you failed to comply with an order of the Commissioner of Labor, whether you are a person of proper competence, judgment, or ability with respect to the operation of a crane, or whether there is good cause to suspend, revoke, or restrict certificate number 19-0038. So more specifically, the examining board will review Mr. Hangy's involvement and conduct in an incident that occurred on May 13th, 2022 at or near 2661 Westlake Road, Penn, New York, in which a crane that Mr. Hangy operated, a hydraulic boom link belt HTC 8690, was involved in the fatality of Ryan Rector. This review will include, but not be limited to, your failure to report such incident as an unusual incident as required by 12 NY CRR subsection 61-37. Such failure to report resulted in the issuance of a notice of violation and order to comply dated October 13, 2023 by the department's Industry Inspection Bureau. So this hearing is being conducted via Teams video conferencing system from Albany, New York hearing site. The court reporter, counsel, and various associated parties and witnesses are appearing remotely in their respective locations. At this time, can I please have the parties note their appearances for the record and where you're appearing from? The city is fine. We'll start with the department's counsel, Mr. Zablo.
Thank you. Good morning, Hearing Officer Semex. My name is Evan Zablo. I'm an associate attorney with the New York State Department of Labor, reporting from Albany, New York. Hearing Officer Semex, you want me to make an appearance on behalf of my intended witness?
Yes, please.
I also have here with me Peter Turco, Associate Safety and Health Inspector within the department's Industry Inspection Bureau. I'm not sure what city he's in right now.
Rochester.
Thank you, Peter. Mr. Turco, reporting from Rochester.
Great, thank you. Mr. Fulvio, excuse me. Will you note your appearance and who you have with you today?
Yes, thank you. Good morning, Hearing Officer Zemix, and good morning, members of the Crane Operators Examining Board. My name is David Fulvio. I'm an attorney with Barclay Damon, and we represent the respondent, Trevor S. Hangy, the subject of this hearing. I am joined by Mr. Hangy, and we are located in Rochester, New York.
Thank you. Now I'm going to ask each of the board members to, again, just introduce themselves for the record. I'll start with you, Mr. Rappaciulo.
Vincent Rappaciulo, joining the call.
We can tell on it, Doc, but we can't hear them.
The other Crane board members, we can't hear you.
Okay, John Dillon,
Oh,
Crane
perfect.
Board member, RC.
Terry Hogle, Crane Board member, Pulaski, New York.
Great, thank you so much. And as I said prior, we will have Jeff Laughlin coming at some point, but we will continue on without him. So if anyone is going to be a witness, I'm going to ask that you just mute your mic and all parties mute their mics so there's no background noise, so the reporter can hear everything that's going on. All parties will be provided an opportunity to be heard and submit any relevant material evidence subject to review by all parties of the proceeding. Each party has a right to cross-examine any witness who testifies. So at an administrative hearing, the general accepted rules of evidence are not strictly applied. I stress that if any party has an objection to a question, the objection needs to be made only once, and the party will have a continuing objection on the record to preserve any rights on appeal. Like all cases, the department will proceed with its direct case, and then the respondent, Mr. Flavio, will have the opportunity to present their direct case thereafter. At the closing of the hearing, we will go off the record, and the board will review the evidence and make its finding and recommendations to the commissioner as part of today's record, or if they choose to submit a report and recommendation to the Commissioner of Labor rather than putting any recommendation on the record. I'm going to ask Mr. Zablo, Mr. Flavio, have you had a opportunity to broach a settlement discussions if interested?
Yes, Your Honor. Me and Mr. Fulvio had some limited conversations a couple weeks ago, and we're here at the hearing today.
Okay. So then at this time, we're going to proceed. The hearing was scheduled to begin at 9:30. It is now 10:58. So I have before me 4 exhibits I would like to introduce into evidence, and all the parties have all the exhibits, correct?
Yes, Your Honor, but it is 9:58, not 10:58.
Oh, sorry, 9:58. Apologies. So as I said, the hearing was scheduled to begin at 9:30. It's now 9:58. So at this time, I have 4 hearing officer exhibits I'd like to offer before we get started with testimony. So I have first before me a notice of hearing designation of hearing officer in the matter of the suspension, revocation, restriction for crane operator certificate of confidence relevance to Trevor Hangy, crane certificate number 19-0038. It is the initial notice of hearing issued by the Commissioner of Labor dated May 17, 2024. I will accept it into evidence as hearing officer exhibit 1. Do we have any objections from any of the parties to have that, the receipt of hearing officer 1?
No objection from the department, Your Honor.
No objection on behalf of the respondent.
Okay, thank you. Having no objection, hearing officer 1 is received into evidence. So then I have before me hearing officer exhibit 2, the affidavit of service, the notice of hearing designation of hearing officer dated May 22nd, 2024. Is there any objections to the receipt of hearing officer exhibit 2 into evidence?
No, Your Honor.
No objection on behalf of respondent.
Hearing officer 2 is received into evidence. So I now have before me hearing officer exhibit 3, notice of appearance and request for adjournment. And this is dated July 2nd, 2024. Is there any objection to the receipt of hearing officer exhibit 3 into evidence?
No, Your Honor.
No objection on behalf of respondent, Your Honor.
Thank you. And then lastly, I have hearing officer exhibit 4, notice of adjournment and rescheduling dated July 8th, 2024. Is there any objection to that being entered into evidence?
No objection from the department, Your Honor.
No objection on behalf of respondent, Your Honor.
Thank you. So having no objections, hearing officer 4 is received into evidence. So that's all the exhibits I have regarding this proceeding. Is there any other pleading or notices?
Not that I'm aware of, Your Honor.
Are there any housekeeping or any other issues that we need to address prior?
Your Honor, I would just like to make the board aware that there is the circumstances of the fatality are currently in litigation. There is a civil case that is currently pending in Ontario County Supreme Court. I would just like to ask that the board be mindful that that matter is pending.
All right, thank you. So if there's nothing further, would either of the parties like to make an opening statement?
Your Honor, I do have an opening statement prepared on behalf of the department.
Then Mr. Fluvio, would you like to make one as well after, or reserved for a later time?
Yes, Your Honor, I'll make a brief opening statement.
Okay, perfect. So since there is no other housekeeping on the record, Mr. Zablo, are you prepared to move forward with your first witness?
Yes, hearing officer Semex, I would like to make a brief opening statement before calling my witness, however.
Yep, go ahead.
Thank you very much. Good morning. Thank you all for your time. This is a very serious matter for all involved. In New York General Business Law 480, the legislature has found, in relevant part, that the operation of cranes involves such elements of danger that special regulations are necessary to ensure that only persons of proper ability and experience shall engage in such operations. That's the end of the paraphrase. Those special regulations would have been codified as Industrial Code Rule 61, created the Crane Operator Board of Examiners, and it requires the board to hold hearings prior to determinations to suspend, revoke, or refuse to issue renewals of crane certificates. Further, the board may suspend, revoke, or refuse to renew a certificate when the board finds that the certificate holder has violated a regulation or law, or failed to comply with an order of the commissioner, when the certificate holder is not an individual of proper competence, judgment, or ability in relation to the certified occupation, in this case, operation of a crane, or for other good cause shown. Turning to the specific matter at hand, the board must now determine whether it should suspend, revoke, or restrict the certificate at issue today based on the documents put into evidence and the testimony elicited today. The department's inspector, Peter Turco, has a very limited role in this hearing. Mr. Turco merely collected evidence for this board to examine and consider here today. Mr. Turco is not here to determine whether the certificate should be suspended, revoked, or restricted. Instead, he is here to provide testimony for the board's benefit. Yes, the department did issue Mr. Hange a notice of violation in order to comply for failing to report an unusual incident under the code rule. However, the department makes no allegation or assertion as to whether the board should suspend, revoke, or restrict Mr. Hange's certificate based on that violation. Instead, the department leaves this issue for the board to make a report and recommendation to the Commissioner of Labor. Thank you.
Thank you, Mr. Zablo. Mr. Fluvio, would you like to
Yes, thank you,
receive
Your
the
Honor.
opening statement?
Yes, thank you, Your Honor. The circumstances of May 13, 2022 were certainly unusual. At issue in this proceeding is whether Mr. Hange reported to the Department of Labor within one business day the tragic events that unfolded on May 13th. Unlike the unusual incident where there's two workers on a job site who may not be familiar with one another and an injury or fatality occurs, the circumstances of May 13th were different. The decedent who fell from Mr. Hange's crane was not just another worker, not just a stranger to Mr. Hange. He was a family member and a friend. Unfortunately, Mr. Hange had to watch as his family member and friend passed away on May 13th, 2022. He immediately called law enforcement. Law enforcement immediately investigated the matter. Mr. Hange then began the process of grieving, both personally and with the decedent's family and his own family. In the aftermath of this horrible event, he missed time from work. and he was consumed by what had happened. Ultimately, 7 days later, the Department of Labor was aware of this incident, and shortly thereafter, Mr. Hange himself relayed the events of the incident, the information that would be required under the regulations to be provided to Mr. Turcow, and the Department of Labor was able to investigate this matter, as was law enforcement and as was the Federal Department of Labor in its OSHA investigation. If there ever was a case where the failure to timely report an unusual incident should be excused, or at least the potential penalty or admonishment that would come with that be reduced or mitigated, this is such a case. We look forward to presenting the testimony of Mr. Hange if the board deems it appropriate. Thank you.
Thank you. Mr. Zablo, are you willing to proceed?
Yes, Your
Or
Honor, I'm
prepared
ready.
to-
Yes, I'm prepared to call my first witness, Your Honor, yes.
All right, thank you. May I call your first witness?
Thank you. I ask Mr. Peter I request Mr. Peter Turcow.
Okay, Mr. Turcow, can you please raise your right hand? Do you solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth under the penalty of perjury?
Yes, Your Honor.
And state your full name for the record, please.
Peter Edward Turco.
Thank you. Okay, the witness is sworn in. You're subject to direct examination from the department's counsel. It's a question and answer format. I'm now going to turn it over to Mr. Zablo. Please proceed.
Thank you very much, Your Honor. Good morning, Mr. Turcow.
Good morning.
Are you currently employed?
Yes,
By whom are you employed?
the New York State Department of Labor.
And what is your current job title?
Associate Safety and Health Inspector.
Approximately how many years have you held that title?
13 years.
Would you briefly describe your job duties as an associate safety and health? Pardon me, Mr. Turco, before I ask you about your job duties, for all 13 years that you've been an associate safety and health inspector, have you been placed within the same bureau?
Yes,
And what bureau would that be?
Industry Inspection Bureau.
Thank you. Can you briefly describe your job duties as an associate safety and health inspector within the Industry Inspection Bureau?
Sure. I perform some of the more difficult or sensitive investigations and inspections. I train, supervise, develop our current staff in the Rochester office and provide information to the public about our particular code rules and informing the public on all of those.
Does the Industry Inspection Bureau cover more than just cranes?
Yes.
What are some examples of other areas that the Industry Inspection Bureau has jurisdiction over?
We have jurisdiction in amusement devices, ski lifts, mobile laser units, cranes, window scaffolds, public assemblies, coin-operated machines, aerial acts. We got a bunch of random things we do.
There's probably some more you haven't mentioned.
Yes.
Excuse me, Mr. Turco, I'm sorry. Do your duties include conducting investigations after certain fatalities?
Yes.
Generally speaking, does the Industry Inspection Bureau maintain investigative files for fatality inspections that it conducts?
Yes.
As part of your job duties as an associate safety and health inspector, do you enforce OSHA standards?
I do not.
Do you enforce OSHA standards with respect to the operation of cranes?
No.
Are you aware of a fatality involving a crane operated by Trevor Hange?
I am.
How did you first become aware of this fatality?
I heard it from another crane person or the news.
Were you eventually assigned to investigate this incident?
Yes.
And previously, you testified that the Bureau, the Industry Inspection Bureau, maintains investigative files for certain fatalities. Did you maintain, did the Bureau maintain an investigative file for this matter?
Yes.
Did you review that file prior to testifying today?
Yes.
I would like to present to you what's been marked for identification as DOL 1. Can you let me know, Mr. Turco, please take out what's been marked for identification as DOL 1, take a brief look at it, and let me know when you're done.
Right. Got it.
Take a quick look at it and let me know when you're done.
Yep, I got it in front of me. I'm all set.
Okay. What is DOL 1?
DOL 1 is my addendum for the incident we are talking about today that happened on May 13th, 2022.
Is this a true and accurate copy of your addendum?
Yes.
Did you create this addendum in the ordinary course of the department's business?
Yes.
Is this part of the department's investigative file in this case?
Yes.
Your Honor, I'd move for DOL 1 to be admitted into evidence.
Mr. Fulvio, do you have any objections?
No objection, Your Honor.
Do the board members have any questions regarding DOL Exhibit 1?
Vince? Can you hear me? Just wanted to let you know that Ben's at the location. He just wanted to make sure someone knew because he wasn't sure if he was on.
So just confirm the board members have no questions regarding this exhibit.
No.
Thank you. Hearing no objections, it is accepted as DOL 1.
Thank you, Your Honor. So, Mr. Turco, you had previously testified that you had heard about the fatality. How did your investigation begin?
My investigation began by speaking with the Yates County Police Department.
Did you speak to any other parties during your investigation?
Yes, I talked to Mr. Hangy as well.
Anyone else?
Not that I can recollect at this moment.
Okay. And so let's talk about your conversation with Mr. Hangy first, if you don't mind. When were you able to get in touch with Mr. Hangy?
On May 26th.
And what were you able to find out from Mr. Hangy on the 26th?
I was able to find out he was in fact the crane operator. I found out that he was the operator when the incident happened. He explained the situation to the best of his knowledge and provided information on how the deceased was rigged on the crane at the time of the accident.
So you said that he had. Were you able to corroborate that withdrawn, excuse me. You testified that Mr. Hangy said that he was the operator of the crane during the incident. Did you verify Mr. Hangy's certificate of competence?
Yes, I did.
Mr. Turco, if you could please take a look at what's been marked for identification as DOL 2, Bates pages 0002.
Yes.
Mr. Turco, what is DOL 2?
DOL 2 is Trevor Hangy's crane certificate of competence.
And were you able, and this, about when was this provided to you?
The day I spoke with him.
And you also testified that Mr. Hangy had explained to the best of his ability how the decedent was rigged or attached to the crane.
Correct.
What information did he give you?
Mr. Hangy stated that that he was rigged with the way that is presented in the later evidence that you'll see in there. He was rigged according to an arborist manual that they had, and I asked if he was properly rigged, and he said he thought so. And I asked if Mr. Hangy had, or the deceased had dual tail lines, and he said he did. And I asked if he was clipped in with both at the time he was raised, and he said he was unsure.
With regards to the, forgive me, I don't recall if you rephrased it as a guidance document, but a document from some type of arborist, some group of arborists, correct?
Yes.
Did Mr. Hangy provide you a copy of that document?
Yes, he did.
I'd like to show you what's been marked for identification as DOL3, Mr. Turco. Can you take a brief look at DOL3 and let me know when you've seen all the pages? This one goes from Bates page 0003 to 0015.
Yes, looking at it right now.
What's DOL3?
DOL3, the title is Guidance for Crane Practices in Arboriculture.
Is this the document that Mr. Hangy referenced during your conversation on the 26th?
Yes, correct.
Pardon me. Your Honor, did I move for DOL2 to be admitted into evidence, Your Honor?
You did not, but I did not want to interrupt you, so.
All right, well, I'll know to go back for that now. Thank you, Your Honor.
Yes.
Okay, and so sorry about that, Mr. Turco. So this DOL3, this is the document that was provided to you by Mr. Hangy?
Correct.
Is this a true and accurate copy of the record that was provided to you by Mr. Hangy?
Yes, it is.
Did you obtain this in the ordinary course of the department's business?
Yes, I have.
Is this part of the department's file in this case?
Yes, it is.
Your Honor, I'd like to move for DOL3 to be admitted into evidence.
Mr. Fluvio, do you have any objections?
I do, Your Honor, on the basis that the notice of hearing refers to a notice of violation that involves the failure to timely report an unusual incident. The document that's being sought for admission into evidence, DOL3, has nothing to do with that. It is merely a guidance document from an unspecified source so far, which relates to the use of a crane by an arborist. Mr. Hangy is a crane operator, not an arborist. He was simply providing his crane operation for the benefit of an arborist at the arborist's direction. I question whether this is relevant to this proceeding. If the proceeding must go in that direction, then it's beyond. It appears beyond the scope of the notice that was given.
Okay,
Your Honor, may I be
noted.
heard?
Yep, please.
Thank you, Your Honor. I believe a plain reading of the notice of hearing will illustrate that while part of this hearing is the fallout from the failure to report the unusual incident, I believe the plain language of the notice shows that we're reviewing the facts of the incident and the facts surrounding the fatality, including the lack of notice of the unusual incident. So I just, I don't think that the notice of hearing is as narrowly tailored as respondent is representing that it is.
All right. Well, the evidentiary rules are significantly relaxed in these proceedings, so I'm going to allow it for whatever weight it may, if it carries weight or not. Do any of the board members have any questions regarding DOL Exhibit 3? Okay, I'm going to receive that into evidence then.
Thank you, Your Honor. Mr. Turco, I'd like to briefly turn back to DOL 2. Would you please turn to that Bates number 0002?
Yes,
Okay. Did you testify that this is a copy of a certificate that was provided to you by Mr. Hangy?
correct.
Is this a true and accurate copy of what was provided to you by Mr. Hangy?
Yes, it is.
Was this obtained in the ordinary course of the department's business?
Yes, it was.
And is DOL 2 part of the department's investigative file in this particular case?
Yes, it is.
Your Honor, pardon, but I'd like to now move for DOL 2 to be admitted into evidence.
Mr. Fulvio, do you have any objections to that?
Your Honor, I have no objection to DOL 2 being admitted.
Okay. Do any of the board members have any questions for DOL Exhibit 2?
No.
No.
So
Thank
we
you, Your Honor.
will, yep, DOL 2 has been accepted into evidence. Thank you. Continue.
Thank you. Mr. Turco, I believe you previously testified that Mr. Hangy told you how the decedent was hooked onto the crane to some degree. Was there any... Did Mr. Hangy provide any targeted information from DOL 3 that showed what happened that day?
Yes, in addition to that packet of the arborist, there is a crane tie-in methods on, what is it, 0013 within that packet that shows that that was the way he was allegedly rigged that day.
And I see on two pages later on 0015, it's a zoom in of page 0013 with it, and there's an arrow here in the file pointing to one of some setup of a crane tie-in. Why is there a note? Why is there a note in the file pointing to this one method?
That was how I was explained by Trevor as to how he was rigged that day.
Okay. You had previously testified that you had also spoken to the sheriff's department, correct?
Correct.
Which sheriff's department did you speak to?
Yates County Sheriff's Office.
And were you able to obtain any records or documentation from the sheriff?
Yes, the police report.
Okay. Mr. Turco, if you could please take a look at what's been marked for identification as DOL 4.
Yes,
What is DOL 4?
that is the Yates County Sheriff's Office police report.
Did you have any conversation? Excuse me. Is this a true and accurate copy of the? And who did you receive this report from? Excuse me.
That would have been in my report that I cannot remember the sheriff's name offhand right now, but I contacted one of the sheriff's department and they provided that.
If you briefly, if you would just take a look at DOL 1, Mr. Turco, and let me know whether or not DOL 1 refreshes your recollection as to who you spoke to from the sheriff's department.
Officer Ron
What I'm-
Spike.
Okay.
Yes, that was his.
So does DOL 1 refresh your recollection as to who you spoke to?
It does.
Who did you speak to?
Officer Ron Spike from the Yates County Sheriff's Department.
Was he able to provide any useful information over the phone?
Just the report.
Okay. All right. And so now turning to DOL 4, is this a true and accurate copy of the report that you received, except for the redactions?
Correct.
Did you obtain this in the ordinary course of the department's business?
Yes.
Is this part of the department's investigative file in this particular case?
Yes, it is.
Thank you, Mr. Turco. Did you speak to anyone else during your investigation?
Not to my knowledge that I can bring up. No.
Did the Industry Inspection
Oh.
Bureau draft or issue any notices of violations in order to comply based as a result of this investigation?
Yes.
Mr. Turco, if you could please direct your attention to what's been marked for identification as DOL 5.
Mr. Zablo, not to interrupt you, you didn't enter DOL
had-
4.
Yeah, I had a brief moment of panic there. But thank you. Let's take a step back, Mr. Turco. I might
Okay.
ask you the same questions again, but I'll ask them. We're looking at DOL 4.
Yes.
Yates County Sheriff's report from Bates pages 0016 to 0019. Is this a true and accurate copy of what the sheriff gave you?
Yes.
And was this obtained in the ordinary course of the department's business?
Correct.
And is this part of the department's file in this case?
Yes, it is.
Then I would now like to please move for DOL 4 to be admitted into evidence.
Mr. Flavio, do you have any objections? Flavio,
No
excuse me.
objection, Your Honor. No objection.
Great, thank you. Does a board member have any questions?
No.
No.
Okay, great. This document will be entered into evidence as DOL Exhibit 4.
Thank you very much, Your Honor. Okay, so Mr. Turco, I believe we can now turn to DOL 5. I believe it's now safe.
Okay.
What is this document?
Just scanning down. DOL 5 is the notice of violation in order to comply from the DOL.
Who drafted this notice of violation?
I did.
Who is it issued to?
Trevor Hangy.
Does it concern more or less the incident that occurred that we're talking about here today?
Yes, it does.
Is this a true and accurate copy of the notice of violation in order to comply that was issued by the department?
Yes, it is.
Did you create this document in the ordinary course of the department's business?
Yes, I did.
Is this part of the department's investigative file in this case?
Yes, it is.
Your Honor, I'd like for DOL 5 to be admitted. I move for DOL 5 to be admitted into evidence.
Mr. Flavio, any objections?
No objection, Your Honor.
Okay, does the board members have any questions regarding this document or exhibit?
It was muted before.
No.
No.
All right, hearing no objections, this is accepted as DOL Exhibit 5.
Thank you, Your Honor. So, Mr. Turco, looking at DOL 5. What section of code did you cite Mr. Hangy for?
Code Rule 61.
And what specific section of Code Rule 61?
Code Rule 61 3.7 and reporting requirements of 1.7.
Okay. And so what does 61-3.7, what obligation does that create for a crane operator?
That's reporting and record keeping, the reporting of any unusual incident or serious incident.
And is there a specific time frame in which unusual incidents have to be reported pursuant to the regulation?
Yes.
Why did Mr. Hangy violate this section of code 61-3.7 according to your order?
I am not aware. I do not know.
Let me rephrase that question then, Mr. Turco. I'm looking here at DOL 5, the notice of violation in order to comply. According to your order, why did Mr. Hangy fail to comply with 61-3.7?
I understand, because he reported it after the business, after the next business day, as required by the reporting and record keeping requirement.
And so this incident occurred on May 3rd. When did you hear about the incident?
It happened
At least in your professional capacity, when were you notified of this incident?
It happened on May 13th, and I was notified on Friday, May 20th.
So now just taking a step back, looking at Code Rule 61 3.7 and 1.7, what's the difference between 3.7 and 1.7? Are they the same thing?
Basically the same thing, it's just broken down into a further detail.
Okay. And so 61-3.7 and 61-1.7, how do these specific sections, how do they protect the safety and health of the people of New York?
It requires, sorry, good.
There may have been an
I was
objection, Peter.
just going to object to the question, as I don't think that's something that he could fully answer. There's a lack of foundation for his ability to answer that question.
I can
Do you want to
ask some
respond to that,
foundational
Mr.
questions.
Zablo?
I can ask some foundational questions, and perhaps that would remedy Mr. Fulvio's concern. Otherwise,
Continue.
Code Rule 61. Okay. So, Mr. Turco, just taking a step back to sort of the foundational questions that I asked you at the beginning of the hearing. I asked you about the job duties, and I also asked you about which areas DOL does have jurisdiction over, correct?
Correct.
And there were some areas where, in terms of the regulations, there's some overlap. Cranes, pyros, and blasters, there's a little bit of overlap there, correct?
Correct.
Which code rule are those rules housed in?
Code Rule 61.
And so, as a part of your day-to-day, do you enforce Code Rule 61?
Correct.
Are you familiar with Code Rule 61?
Yes.
I'll ask the question, now that there's been some foundation, I'll ask the question again. Mr. Turco, how does Industrial Code Rule 61-3.7 and 1.7, how do they protect the safety and health of the people of New York? Just get Mr. Turco, give opposing counsel a moment here.
Sure.
To unmute.
I mean, I'll note my continued objection for the record, but I think we could proceed.
Yeah, we can continue.
Mr. Turco, can you answer the question? How does 61-3.7 and 1.7 protect the safety and health of the people of New York?
It ensures that the crane operators report any accident or serious incident, unusual incident to the Department of Labor so that we can investigate to the best of our abilities to find out what happened and to ensure that that crane operator is in fact doing what our code rule states.
Thank you, Mr. Turco. Mr. Turco, were you aware that OSHA had also conducted an investigation of this incident?
I am aware.
During the time of your investigation, so this notice of violation, it's dated October 13th, 2023. So on or before October 13th, 2023, did you have any access to OSHA's investigative records or any records from OSHA?
No.
Thereafter, did there come a time that the Bureau was able to obtain records from OSHA?
Yes.
Do you know by what means the Bureau was able to obtain those records?
Through FOIL.
Were those records added to were those OSHA records added to the investigative file in this case?
Yes, they were.
Okay. Mr. Turco, I'd like to now turn your attention to what's been marked for identification as DOL 6.
Okay.
What is DOL 6, Mr. Turco?
DOL 6 is OSHA's contact sheet that was provided to industry inspection.
Okay. Is this a true and accurate copy of the OSHA contact sheet that was provided by OSHA?
Yes,
Was this obtained in the ordinary course of the department's business?
it was.
Is it part of the department's investigative file in this case?
It is.
Your Honor, I move for DOL 6 to be admitted into evidence.
Any objection?
Yes, Your Honor. I would object to the inclusion of the OSHA documents in this proceeding. Those are documents that were generated by a separate agency as it conducted an investigation in regards to Mr. Hangy's employer, Wilcox Crane. The OSHA regulations are not state regulations. The OSHA investigation is not something the state has jurisdiction over. And frankly, the OSHA investigation is completely irrelevant to this hearing, including whether Mr. Hangy reported in a timely manner the incident or whether he's otherwise competent to operate a crane.
Your Honor, the department's intending to excuse me, Your Honor. The department is intending to submit these OSHA records into evidence so that the board may review them and provide the board the opportunity to determine whether there's any whether there's any probative value in these records. And the board can give these OSHA records the weight that it's given.
Your Honor, if I may add, I would
Yeah.
I would further like to point out that there is no adjudicated findings included in these OSHA records, and that is because there was no actual formal adjudication. Mr. Hangy's employer did not have a chance to actually, litigate the issue with OSHA. I would further note that there is a document that was executed between Wilcox and OSHA, which would preclude the use of these which I guess would have to be separately provided in a supplemental submission that would preclude the use of these in a proceeding for the basis of finding any form of liability. Putting that aside, again, all these documents show is that an investigation occurred, that there was a citation, which is merely essentially an accusatory instrument, much like a notice of violation, and then ultimately that a fine, was levied. It doesn't provide the factual basis, for the allegations contained in the citation. It doesn't demonstrate that those factual allegations were actually proven and demonstrated in a venue of competent jurisdiction. I don't see how they would provide any guidance whatsoever to the board in assessing whether Mr. Hangy is competent to operate a crane.
Your Honor, my response to that is that the records speak for themselves. There's photos of equipment, there's narratives of investigators, there's statements. If the board doesn't believe there's any value, then let the board give these documents no weight. I'm not aware the document that Mr. Fulvio is speaking of with regards to, for lack of a better term, confidentiality. I'm not aware of the existence of that record, so I can't comment on it.
All right, I'm going to allow it in, but your objection is preserved. So I'm going to have this received as DOL 6. Do any of the board members have any questions regarding this document or this exhibit?
No.
Yeah.
All right. Continue, Mr. Zabayo.
Yes, hearing officer, CEMEX. Okay, Mr. Turco. Just give me one more moment, Your Honor.
Take your time.
Okay, Your Honor, it looks like there's a little error in my exhibits here. It seems that Bates pages 0022 and 0023 should be DOL 7 and not DOL 6. So the sticker went 2 pages later than it should have. Can I ask everyone to write DOL 7 on page 0022 instead of 24, Your Honor, or is there a better way to handle this?
Yep, that's fine.
Okay, Mr.
Does-
Turco. Yes, Your Honor?
So 0022 is DOL 6 or 7.
DOL 7. Yeah, yes,
Okay.
yes. The DOL Exhibit 7 sticker is on page 0024. It should have been on 0022. My apologies.
Okay.
So, Mr. Turco, if you can turn your attention to Bates page 0022.
Yep.
Through 0030. What has now been marked for identification as DOL 7.
Correct.
What is DOL? To the best of your understanding, what is DOL 7?
It appears to be an OSHA, something with OSHA and fines, notification of penalty, citations.
And to which employer is this correspondence directed?
Wilcox Crane Company.
Is this a true and accurate copy of the penalty records that industry received from OSHA?
Yes.
Was this obtained in the ordinary course of the department's business?
Yes, it was.
Is it part of the department's investigative file in this particular case?
Yes, it is.
Your Honor, I move for DOL 7 to be admitted into evidence.
Mr. Fluvio, objection?
I will note my same objection as raised previously with DOL 6. It is a continuing objection, as is the
Okay.
line of questioning regarding the OSHA documents.
Okay. As I said, I'm going to allow it for whatever weight it may bring, if it brings any. Do any of the board members have any questions regarding DOL Exhibit 7? Okay. So it was received into evidence, DOL 7.
Okay, Mr. Turco, turning to DOL 8, Bates number 0032. What is DOL 8?
A safety narrative to Wilcox Crane Company.
Is a safety narrative akin to your addendum? It's similar to your addendum?
It looks similar to what I have, yes.
And which employer was the subject of the safety narrative?
Wilcox Crane Company.
Does it concern the incident that we're here to discuss today?
Yes, it does.
Does the narrative concern Trevor Hange?
Yes, it does.
Is it a true and accurate copy of the safety narrative that industry received from OSHA?
Yes.
Was it obtained in the ordinary course of the department's business?
Yes, it was.
And is it part of the department's file, investigative file in this case?
Yes, it is.
Your Honor, I move for DOL 8 to be admitted into evidence.
Mr. Fluvio?
Your Honor, same objection as with DOL 6 and 7. I would further note that while I appreciate that the rules of evidence are relaxed, in this instance, we don't even know who the declarant of this document is. So while I understand hearsay is admissible, we don't even know who the author of this document is. But nonetheless, I continue my objection for the same grounds raised with the other OSHA materials.
Mr. Zablau, how do you want to respond to that?
My only response, Your Honor, is that these are authenticated documents obtained directly from OSHA pursuant to a FOIA request. They're in the department's investigative file, so pursuant to SAPA Article 3, they should go in this. They should be entered into this proceeding, and the the board and the commissioner can give it whatever weight it deserves.
Okay, I am going to allow it. DOL 8 received into evidence.
Thank you, Your Honor. Mr. Turco, can we please look at what's been marked for identification as DOL 9?
Yes.
What is DOL 9?
Department of Labor photo mounting worksheet.
Which Department of Labor?
The United States Department of Labor.
Thank you, Mr. Turco. And generally speaking, what events do these photos concern?
Some of the cranes being used by Wilcox Crane Company. Looks like photos of the rigging used by the deceased, and statements. Well, I take that back. Not statements, just pictures.
Correct.
Pictures
Yeah,
of the
DOL
crane and the
9.
rigging. Yeah, I
DOL
went into the
9
other one.
ends. Yeah, it ends on page 0040. Yes.
Yep.
Are these true and accurate copies of the photos provided by OSHA?
Yes.
Were these obtained in the ordinary course of the department's business?
Correct.
Are they part of the department's investigative file in this particular case?
Yes, they are.
Your Honor, I move for DOL 9 to be admitted into evidence.
Fulvio,
I do not have an objection to the photos being admitted. Thank you.
do any of the board members have any questions regarding DOL 9?
No.
No.
Okay. Hearing no objections, DOL 9 is received into evidence.
Thank you, Your Honor. Okay, Mr. Turco. There were other records that were obtained by OSHA. Can you please direct your attention to DOL 10?
Okay.
That begins on 0041 and concludes on 0044. What is DOL 10?
DOL 10 is the Yates County Sheriff's Department witness statements.
Were these obtained through from OSHA through the FOIA request?
Correct.
Are these true and accurate copies of the Sheriff's Department statements that were
Yes.
provided to you by OSHA?
Correct.
Were these obtained in the ordinary course of the department's business?
Yes, they were.
Are they part of the department's investigative file in this particular case?
Yes, they are.
And so on what dates are these statements taken?
5/13/22, May 13th. Day
And
of.
do these appear to concern the fatality incident that we're here today to discuss?
Yes, they do.
Your Honor, I move for DOL 10 to be admitted into evidence.
Mr. Fulvio, do you have any objections?
No objection to the statements coming in.
All right. Do the board members have any questions regarding DOL 10?
No.
No.
All right. Having no objections, this is entered into evidence as DOL 10.
All right, and lastly, Mr. Turco, please turn your attention to DOL 11, 0045 to 0046.
Okay.
What is DOL 11?
DOL 11 is United States Department of Labor, OSHA document, and it appears to be a witness statement.
Does it concern the events that we're here to discuss today?
Yes, it does.
Is this a true and accurate copy of the witness statement provided to industry from OSHA?
Yes, it is.
Was this obtained in the ordinary course of the department's business?
Yes, it was.
Is this part of the department's investigative file in this case?
Yes, it is.
Yeah.
I move for DOL 11 to be admitted into evidence, Your Honor.
Mr. Fulvio?
no objection to the statement coming in.
Okay, here. And did board members have any questions regarding DOL 11?
No.
Okay, hearing no objections, DOL 11 has been received into evidence.
Thank you, Your Honor. Your Honor, I have no further questions for Mr. Turco.
Great. Mr. Fluvio, do you have any questions for Mr. Turco?
I do, Your Honor.
Okay, Mr. Turco, you're now subject to cross-examination by the respondent's attorney, Mr. Fluvio. You can proceed.
Mr. Turco, how long have you been an investigator for the Industry Inspection Bureau?
Approximately 13 years.
And prior to 13 years ago, did you have any other additional investigative experience?
No.
During the course of your 13 years of experience, are you able to approximate how many investigations you've conducted?
Off the top of my head, I couldn't tell you.
Now, generally, upon receiving notice of an unusual incident, as that term is defined, 12 NYC-R Part 61, could you describe the steps that you take to commence an investigation?
Sure. It starts with contacting any official body that has been to the scene, whether, we're contacting the police and or OSHA or anybody else that may have been involved in the incident, along with the company and people involved.
So typically when an unusual incident occurs, is the first investigative body involved usually local law enforcement?
Usually that's how it goes.
Okay. And that is because there's usually an emergency, someone calls 911 and law enforcement arrives on the scene, correct?
Yes.
Okay. And then law enforcement proceeds to process the scene, conduct an investigation, and to prepare an accident report. Is that correct?
I assume that's how it would go, yes.
Okay. And so it's fair to say that given that the reporting requirement is the following business day, the reporting requirement of an unusual incident, Department of Labor, by the time the Department of Labor commences its investigation, typically the accident scene itself has already been processed and cleaned up. All right.
Sometimes that happens, yes.
Well, you say sometimes, but that's usually the case. Is that not right?
Yes, usually that is the case.
So in terms of observations of the accident scene, the immediate circumstances of an incident, the Department of Labor relies upon the investigative work of local law enforcement, typically, correct?
Sometimes, but not always. Sometimes we are on the scene very close to the time it happens.
And again, the purpose of the Department of Labor investigating an unusual incident, could you describe to me your understanding of what that purpose is?
The purpose of responding to an unusual incident is to find out what happened and to see if it corresponds with our code rules, to find out if there's any issues with the competence of whatever jurisdiction that may be.
So in a scenario where an unusual incident occurs, and you've conducted an investigation, and you determine that there's a competency issue in how a piece of equipment was operated, for example. Would that result in you issuing some sort of finding or notice of violation bearing upon those safety issues?
Yes.
And is that correct? That would be in the form of a notice of violation, and that would trigger the type of hearing that we're here for today. Is that right?
Yes. I don't know if that happens in every case, but in this one, yes.
Well, I just want to know about the general case in which there's an unusual incident. You do an investigation, you find that the unusual incident resulted from incompetence or misuse of equipment. What would you do next upon making that determination?
Then I send that up to my supervisory staff and they determine that from there. And then that gets sent up to the Crane board and or anybody else, counsel's office, anybody else who needs to be involved.
Okay. So would there be a document that is issued, whether it be a notice of violation or some other document that spells out to the crane operator or the operator of equipment at issue in that incident that it is alleged that they operated the equipment incompetently or they misused it?
Yes, there is usually a description of what happened within the violation.
Now, in this case, there is no such document that says that Mr. Hange operated his crane in an incompetent manner or misused it. Is that right?
In this case, no, correct.
And instead, the only issue you took with Mr. Hange is his failure to report the unusual incident within a timely manner. Is that right?
That is correct.
So as you sit here today in this proceeding, despite the inclusion of those OSHA documents and other materials, you're not alleging that Mr. Hange was incompetent or misused his crane on May 13, 2022, right?
It's kind of a loaded question, but yeah, no, we are not alleging that.
And in fact, you're familiar with the police report that was included as an exhibit here today. Is that right?
That is correct.
And you would agree that in the police report, the suggestion is made that the decedent arborist misused his own equipment. Is that correct?
Objection, Your Honor. The document speaks for itself.
I'm just confirming his understanding of the materials he reviewed as part of his investigation, which are admitted into evidence.
If he has an answer, I'll allow it.
Could you restate the question?
Yeah, can I have the court reporter read it back?
Sure, let me try one moment. So sorry.
No problem.
I'm sorry.
If easier, I could just restate the question. My question for you,
I
Mr.
apologize.
Turcow. Yeah, no problem. My question for you, Mr. Turcow, was simply, is it your understanding that the police report on this incident referred to the fact that, the decedent had apparently misused his own safety equipment.
That could be one way of reading it. Yes, that appears to be part of it. Yes.
Well, you would agree there's nothing in the police report that suggests that Mr. Hange misused his crane, correct?
There's nothing in there. No, the police are reporting on the fatality, not the crane operator.
Now, my understanding is you learned of this incident approximately 1 week after it occurred. Is that correct?
Correct.
And then in the days following you learning of this incident, you had a discussion with my client, Mr. Hange. Is that right?
That is correct.
And in that discussion, Mr. Hange informed you of the details of the incident, correct?
Correct.
Including what you would understand to be his reporting obligation that he was required under Part 61.
Correct.
And much like any other investigation that you perform of an unusual incident that's timely reported, you were able to obtain materials from local law enforcement and other investigative agencies that performed an investigation of the accident, correct?
Correct.
So it's fair to say that even though the incident was not reported in a timely manner, there was nothing unusual or restricted with respect to your investigation as compared to how it would otherwise be if it were timely reported, correct?
No, if it's timely reported, I get my opportunity to do my investigation of the unusual incident. And in some of these cases where I am not allowed to do that, that is a different investigation, one where I am not able to see or see any of the equipment or see the scene of the accident.
Okay, so May 13, 2022, you would agree that that was a Friday, correct?
Correct.
So that means Mr. Hange's reporting obligation gave him, or he had until the following Monday at 5 p.m. to report this incident, correct?
Correct.
So if he had reported this incident to you on 4:59 p.m. on Monday, the Monday after the incident, we would not be here today, correct?
That appears to be the case.
So if he had reported this incident to you the following Monday at 4:59 p.m., what would you have done differently with respect to your investigation?
I would have went on the scene. We prefer to get it even sooner, right when the accident happens and when the police are called. But we would have more of a chance to see what was on site, see the crane, possibly see the deceased, and to actually get to see the some of the materials in person and see the place in person, the scene.
You don't have any reason to believe that the decedent was located at the scene of the incident on Monday, the following Monday at 4:59 p.m. or the Tuesday morning if you were reacting to a report at Monday 4:59 p.m. Correct?
Correct.
You don't even have reason to believe that the crane itself was located at the scene where this incident occurred, late Monday, early Tuesday after it had happened. Correct?
That I don't know. I don't know if it still would be there. There have been cases where a crane stays on site and stays up and erected for multiple days, but I do not know in this case.
Okay. Well, in this case, this was a residence, not a commercial location, correct?
Correct.
And it was not an ongoing construction site, correct?
Correct.
And ultimately, If you wanted to inspect the crane to examine the crane's components and condition, you could contact Wilcox and Wilcox would make it available for you, correct?
Correct. That
Objection, Your Honor. Mr. Turco does not know what the employer would do if he were to ask him. It's a lot of hypotheticals, Your Honor.
Well, let me ask you this. Have you ever asked Wilcox to inspect the crane at issue?
for
Anyone
this
from
case,
Wilcox, whether it be Mr. Hangy or anybody else.
have I ever, are you asking me, have I ever asked a crane company to inspect their crane after an unusual incident?
This particular crane company, Wilcox Crane, in regards to this
particular
incident.
In this particular incident, no, it was already gone from the scene.
But again, if you received a report of the incident on the following Monday at 4:59 p.m., again, it was likely already gone from the scene, correct?
Assuming so, yes. Yes, I would assume that would have not been on the scene. I don't know for 100% certain, but I assume it would be.
So again, even if this was timely reported, you would not have had the opportunity to investigate the crane at the scene.
Well, if it was timely reported within 24 hours, 1 hour, if that was called, I would be able to see the crane.
But that's not the reporting obligation, correct?
That is not the reporting obligation.
I guess I just want to make clear for the record.
Sure.
Mr. Hangy could have complied with the reporting obligation, and you still would not have had access to the crane at the scene. Is that right?
Correct.
So aside from the aspirational reporting, there are situations where the reporting of an unusual incident within the parameters of the regulation would not have afforded you any further access to the scene, the equipment, or any other investigative materials than you were in this case. Is that right?
And I guess I'll repeat my answer. If within that obligation, yes. If it was before 5 o'clock on Monday, yes. But if he did it immediately that day, then I would have had the opportunity.
Now, I don't want to belabor this particular point, but DOL 3, this was a document provided to you by Mr. Hangy, is that right?
Correct.
So as you sit here today, you're not asserting that the standards identified in that document are applicable in the state of New York, are you?
No, those are not applicable.
Was your understanding that Mr. Hangy was providing you this document in an effort to assist in trying to figure out how this incident happened?
Yes.
So you would agree that Mr. Hangy was cooperative once you did have contact with him to conduct your investigation, correct?
That is correct.
Have you ever, are you aware of whether Mr. Hangy ever had any other notices of violation in connection with his crane operator's license?
No, I don't believe he had any other violation within our department.
And he's had his license since 2019, is that right?
Yes.
Were you aware that the decedent was a relative of Mr. Hanges?
Yes, I found out that after the fact, yes.
Okay, thank you, Mr. Turcow. I have nothing further.
Thank you.
Mr. Zablow, Zablow, excuse me, I'm going to turn it back over to you. Do you have any redirect?
I have very limited and very brief redirect, yes. Thank you, Your Honor.
Yep.
So, Mr. Turco, I just want to clear up some questions. Earlier during Mr. Fulvio's questioning, he asked you if the record keeping was the only issue that you took. I didn't catch the exact question, but there was a question of this was the only issue that you took with what you saw, the record keeping, or lack of reporting. Excuse me.
Mm-hmm.
Do you know how cranes and arborists should be hooked up to each other such that they could trim a tree?
I'm familiar of a few different ways, but I am not a rigging expert per se or a tree person.
So you're familiar with some of these practices, but do you know about these practices? Do you know how arborists and crane operators should communicate on any given job?
No.
You don't really have the ability to take issue with that because you don't know, correct?
That would be correct.
Later on in the questioning, Mr. Fulvio said something along the lines of, and forgive me if I'm paraphrasing incorrectly, but it was something along the lines of, had you have not issued that notice of violation, Mr. Turco, well, then we would never be here today. And I believe you answered yes to that question. Does that sound familiar?
Yes, it does.
How do you know that we wouldn't be here? Do you know whether any of your supervisors would have, let's say you didn't find this violation and you sent the report up, we're talking about hypotheticals here, but it's to prove the point. Let's say you did not find or didn't notice this single violation. You did your investigation, you send the report up to your supervisors. Is it true? Is it possible that your supervisors or someone in management, is it true that someone other than you makes the decision as to whether or not any investigation is going to go to hearing?
Absolutely.
Do you make the decision as to whether or not any investigation goes to hearing?
No, I do not.
Do you have any way to know whether or not this hearing would be held if you did not find that one violation on that NOV? Do you have any way of knowing that?
I do not know. No.
And the last item to clear up in reference to DOL 3. DOL 3 represent the page itself, page 0003 says it's guidance for crane practices in arboriculture.
Correct.
And so you had said that this is not applicable in New York. What did you mean by that?
Well, this is a guide from the Maine Arborists Association, different state.
Are you aware as to whether or not OSHA allows for practices similar to this or different than this, than what's provided in DOL 3?
No, I have no idea.
So when you say that it's not applicable in New York, is that based on any type of legal research?
No.
Is that opinion that it's not applicable in New York based solely on the fact that this is a document from the Maine Arborists Association?
That is correct.
No further questions, Your Honor.
Thank you. Mr. Fulvio?
Yeah, Your Honor, I just have a few more.
Go ahead.
Mr. Turkow, during redirect, you discussed that in order for an investigation to go to hearing, there must be someone, I guess, above you, a supervisor of some kind, that directs it to be the case. Is that right?
Yes,
But you were the investigator assigned to investigate the May 13, 2022 fatality at issue and subsequent failure to report at issue in this hearing. Is that correct?
that is correct.
Was anybody else?
Was anybody else assigned to the
Was
investigation?
anybody else with the Department of Labor, the New York State Department of Labor, assigned to investigate this incident other than yourself?
No,
And in order for those supervisors or those superiors in the Department of Labor to direct that an investigation goes to hearing, they need to see something in your report of the investigation that suggests it should go to a hearing. Is that right?
I don't know what process they have when it goes above me, to be honest.
Well, in this case, did you provide a report to your superiors?
Yes, I did.
Aside from referring to Mr. Hange's late reporting of the incident, what were the contents of that report?
And you're speaking about my addendum specifically, number DOL Exhibit 1?
So is that the document that goes to your superiors to determine whether this should go to a hearing?
Yes.
Or is there some other document? Okay. And nowhere in your report, your addendum, UL1, does it say, aside from the reporting requirement, that Mr. Hange violated any particular standard, rule, or regulation in connection with how he operated his crane. Is that right?
I just dictated and put down what I knew from this particular case, and then that gets sent up for somebody else to determine.
After it's sent up, do you have any follow-up conversations or written correspondence with those who make that as to whether to go to a hearing?
Not really. No, I didn't hear anything for quite a little bit, and then we did issue a violation. So yes, I do speak with my supervisors, and when it goes higher than that, I don't have, I speak less to people when it goes down up that far.
And again, your testimony earlier was that when you investigated an unusual incident, it's to ascertain whether the licensed person involved in the incident, is potentially incompetent or misused their equipment and is a safety risk going forward, correct?
Correct.
And so in order to make that determination, you have to have some level of understanding as to how equipment should be operated in a safe manner, correct?
Correct.
So in the ordinary case of investigating an unusual incident, you are equipped to identify whether an operator of equipment has misused or has demonstrated incompetence in their use of equipment, correct?
Correct.
And typically, when you fill out your addendum or report to your superiors outlining the results of your investigation, if you determine that the operator of equipment misused or was incompetent in the use of their equipment, you would set that forth in your document, correct?
Again, I just write down what happened in that particular case, and that is for someone else to determine.
And in previous cases, when you're found incompetence, have you included in your addendum the reasons why you believe somebody had engaged in incompetence or misused their equipment?
In some violations, we do when that's determined, but in my addendum, I'm strictly stating facts I'm gathering from the investigation.
Now, you don't know whether Mr. Hange had firsthand knowledge as to how the decedent was actually affixed or attached to the crane. Is that right?
Could you ask that again? Are you saying?
Yeah. Yeah. Do you know? I guess I'll ask it more direct. Do you
Okay.
know whether or not Mr. Hange actually personally observed how the decedent was affixed to the crane?
I asked him.
And do you know whether he said he knew for sure or he believed it to be the case?
He said he was unsure.
And is it your understanding Mr. Hange was located in the body of the crane, operating the crane at the time the decedent went up on the crane?
That is what I was told, yes.
And they communicated through headset, correct?
Yes.
And what if anything, did Mr. Hange tell you was communicated through the headset between the two of them?
He said not much. I mean, he said he was up there and basically heard a click, and then a few seconds later saw the deceased go in front of his crane and fall as he was switching over.
But was your understanding that everything up to that point wasn't otherwise unusual?
No, I don't agree with that.
Okay. Could you explain why?
Because the crane operator did not know how the deceased was rigged. And that is usually the crane operator's responsibility for the safety of the entire crane and who is rigged on it and what load they are picking up.
What is your basis for saying that?
That is our code rule.
Could you
For a
point
crane.
me to which one? Could you point me to which one?
For the safety for a crane operator.
Yes.
That's I couldn't, I guess, point to the exact number, but that is part of a crane operator's responsibility is to look over their whole crane, make sure it's properly rigged and know what they're lifting. And if it's a person, yeah, if you're properly rigged or if you're on the actual ball per se.
And you didn't reference this particular regulation that you're referring to in your addendum or notice of violation, correct?
No, I just stated the facts of what Mr. Hange told me over the phone.
And are you aware that the decedent was an arborist who hired Mr. Hange to provide the lift for him?
I don't usually get into the business dealings of it. I'm not exactly aware of that's the exact transaction or how that worked.
So that didn't come up in your discussions with Mr. Hange during your investigation?
About who hired who for the job?
Correct.
No, not about exactly who hired who, not that I can remember.
Um, Yeah, so is it your belief that well, let me strike that question. Do you have any knowledge through your investigation as to whether the decedent made a determination as a professional arborist with knowledge as to the appropriate safety protocols for accessing trees, as to whether utilization of a crane would actually be the safest methodology for accessing the tree at issue in this case?
I don't know what his knowledge is. I assume he had that training. Yes.
And you would agree that in the document that Mr. Hangy provided to you, DOL3, it does say that there is an exception that permits an arborist to utilize a crane, provided they make a determination as to whether it's the safest means possible, correct?
Correct.
Mr. Zablo, was there an objection?
Not in time, there wasn't, Your Honor.
Okay.
Sorry.
Mr. Fubio, continue.
Yep. So it's possible that that determination was made by the decedent, correct? We just don't know, right?
Objection, Your Honor. This is a document that we're referring to DOL3. This is a document that Mr. Turco doesn't really have any knowledge on. He just received it and has passed it on. So the contents of which, the policy of some Maine arborists, and what can and cannot be done in conjunction with OSHA rules and regs. Mr. Turco's already testified he does not enforce OSHA regulations. This is outside the scope of his professional knowledge. And therefore, his answer has no probative value.
Your Honor, I believe that's the objection that my esteemed colleague, Mr. Zablo, wanted to make to the previous question. But my most recent question was whether was just clarifying that we have no knowledge one way or the other as to whether the decedent made any determination prior to being elevated or hoisted on the crane as to, whether it was the safest means to do so. I would also add that this very exhibit is submitted by the department. So to suddenly object to it as being irrelevant, that doesn't really add up.
Yeah, I did not object to the relevance of the exhibit. I just objected to Mr. Turco's answering questions on a document that he doesn't have any professional knowledge about. These are terms of art in here. Whether an arborist has made a determination, this is just outside the scope of Mr. Turco's understanding. He doesn't regulate cranes. He doesn't regulate the operation of cranes. He doesn't enforce OSHA standards.
All right.
His answer has no value.
I'll sustain it. Keep going, Mr. Fubio.
Mr. Turco, during the course of your investigation, were you aware that the tree that the arborist, in this case, was seeking to access had been rotted?
According to the reports, that is the case.
So is it your understanding that because it was rotted, he would not have been able to climb it safely?
If it was rotted and that was his determination, yes.
And you have no reason to dispute that determination, correct?
No,
Objection, Your Honor. There's been no determination. We don't know
Those were
what
his words.
this is a hypothetical determination. So this is if there was any determination, this is a fact that's not in the record that Mr. Turco is being asked questions about.
Mr. Turco used the word determination, not me, until I asked my question following up.
Okay, I'll sustain it. Continue, Mr. Fluvio. Are you aware of other means to access a tree aside from climbing it or using a crane as an arborist?
no.
Okay, I have nothing further. Thank you.
Thank you. Mr. Zablo?
Even more limited, even more brief. Redirect, Your Honor. Mr. Turco, I believe during questioning you had mentioned some operator responsibility to see the load that he's lifting. Did you state something about that?
I did.
Do you know whether or not that responsibility that you mentioned is found in either federal or state law? Do you know whether that is found in federal or state law?
I don't know.
No further questions, Your Honor.
Mr. Fluvio, anything else?
Sorry, Your Honor, I don't mean to belabor this, but my understanding of your testimony earlier was that there was a regulation within Part 61 that you said required the crane operator to see the load. Was I mistaken in hearing your testimony?
That was for Code Rule 61, which is license and certificates for the actual crane license. And we also have some other codes that involve cranes and crane safety.
Okay. But you just answered that there is no state or federal regulation that you're aware of that requires the crane operator to see the contents of his load. Did I hear that correctly?
Well, not, I mean, you can see a lot. Yes. Yes, yes.
Okay. So then you would agree there is no state or federal regulation that required Mr. Hange to determine that the decedent had properly tied his harness as an arborist, or had properly maintained the how he was affixed to the crane as he was hoisted up when Mr. Hange operated the crane, correct?
Objection, Your Honor. The witness is being asked whether there are any state or federal laws. Can it please be, are there any state or federal laws that he is aware of?
That's fine. That you're aware of.
Thank you.
Mr. Turco, you can answer if you know the answer.
You're asking if there are any state laws that I am aware of for that,
State or federal.
for how to affix a person.
No, for the crane operator's awareness for how somebody is affixed to their crane.
I can't state one off the top of my head right now, the exact, any code rule per se for that.
Now, you would agree that the state of New York does not have jurisdiction to enforce federal regulations, is that right?
That is correct.
That is for OSHA to handle, typically in these sorts of cases, is that correct?
Yes, typically, I suppose.
I have nothing further.
Mr. Zablo?
Nothing from me, Your Honor.
Okay, I'm going to ask the board members, do you have any questions for Mr. Turco?
Sorry, I was muted. Go ahead. No.
No,
No.
Mr. Turco, if the incident had been reported, at any point, on Friday, May 13th, would you have inspected, after hours on Friday, May 13th, or in the 2 days preceding Monday?
Absolutely.
Does anybody have anything further for this witness? All right, if there is nothing further from Mr. Peter Turco, your testimony is complete and you're excused. Thank you for your time and attendance in this proceeding.
Thank you.
Do the parties want to take a break? It is now 11:37. Do we want to continue? Do we want to take a short break? How are the parties feeling?
Your Honor, I would appreciate a brief recess if possible.
Sure. How long are you looking for?
10, 15 minutes.
All right. Is that out, Mr. Zablo? Is that fine with you?
Yes, Your Honor.
Okay, so why don't we come back at 11:50 if that's fine with everybody?
Thank you.
All right,
Your
thank you.
Honor.
All right, are all the parties back? Mr. Zablo, Mr. Cluvio, I believe all of the Crane board members are here.
yes.
So Aaron, let's go back on the record.
Sure. On the record, the time is 11:53 a.m.
Okay, so we are back on the record now. Mr. Zablo, do you have any other witnesses?
No, Your Honor. No further witnesses. The department rests.
So, Mr. Fluvio, do you have a case in chief you would like to present? Do you want to take a longer intermission? Does everybody want to? It's almost noon time. I know that we just took a 10, 12-minute recess. Do we want to take a break? Do we want to keep on going?
Well, Your Honor, in order to make an informed decision on this for everybody else, I would like to state that we will not be putting on a case in chief. I will not be calling any witnesses or presenting any evidence.
So then, Mr. Fluvio, you rest then.
Yes, the respondent rests.
All right, I appreciate that. Do any of the parties want to make any closing statements?
Your Honor, given I was anticipating a direct case on behalf of the respondent, so if we're going to move on to closing statements, I'd like some time to finish preparing one, and perhaps among other things.
Okay. Then do we want to then take, we can go call for lunch now, reconvene at 1 o'clock. Would that work for all the parties?
That would work for me, Your Honor. Yes.
Fine.
Mr.
Thank you.
Fluvio, does that work for you?
Yes, it does, Your Honor.
Okay, so let's reconvene at 1 o'clock. Is that acceptable with all the board members as well?
Yes. Yes, so, yeah.
Okay, perfect. So 1 o'clock, we will all be back here and we can go off the record. It is 11:54.
Thank you, Your Honor.
Thank you.
Thanks.
think we're all here now. Syracuse, do we have both Crane Board members there?
Yes.
Yep. Yeah.
Okay.
Okay, perfect. And we have both attorneys, so I think at this point we can go back on the record.
Okay, on the record, the time is 1:03 PM.
Okay, thank you. So at this point, from my understanding, both parties have rested their case. Mr. Zablo, you wanting to make a closing statement, and Mr. Fluvio, would you like to make a closing statement as well?
Yes, Your Honor.
Yes, I would, Your Honor.
Okay, perfect. So we'll first go with the department, and then you will go after Mr. Fluvio. Thank you.
Thank you very much, Your Honor. And thank you, members of the Crane Board. Members of the Crane Board, it's important to understand that you are the experts here. The board here has the knowledge and the expertise regarding crane operations that's required. Do not let respondents' questions to Mr. Turco distract you. Mr. Turco did his job. He conducted the investigation and provided his observations and documents to the board here today for the board to consider. It's now for the board to consider whether Mr. Hange's acts or omissions demonstrate that the certificate should be suspended, revoked, or restricted. As a reminder, the board may suspend, revoke, or refuse to renew a certificate on the grounds that are laid out in Industrial Code Rule 61-1.5F1. Those grounds are the certificate holder has violated a regulation or law or failed to comply with an order of the commissioner. The certificate holder is not an individual of proper competence, judgment, or ability in relation to the certified occupation, or for other good cause shown. With this in mind, the board must use its expertise to consider the evidence and testimony produced today to determine whether the board should suspend, revoke, or restrict the certificate. Thank you.
Thank you, Mr. Flo. Mr. Fluvio, would you like to proceed?
Yes, thank you, Your Honor. The evidence presented today reveals that on May 13, 2022, my client, Mr. Hange, was operating a crane, and during the course of that operation, an individual named Ryan Rector, the deceased, fell ultimately to his death. This was certainly an unusual incident, and in the aftermath of that incident, Mr. Hange ultimately reported it to the Department of Labor. At issue before us today is the fact that Mr. Hange did not report to the Department of Labor that incident by the close of business the following Monday. The incident occurred on Friday, May 13th, and therefore under the regulations, he had until 4:59 p.m. or 5 o'clock p.m. The following Monday, May 16th, to report this incident. Mr. Turcow, the inspector for the department, acknowledged that during the ordinary course of his investigations, he is tasked with, reviewing the findings of investigative agencies and formulating his own opinions and conclusions in the aftermath of an unusual incident. That is still what happened here. Had Mr. Hange reported this incident on Monday, May 16, 2022, at 4:59 p.m., as was his right, then nothing would have been different in terms of the department's investigation. The accident scene would not have been preserved. The body would have been cleared. The crane would not have remained on site. Unlike other job sites where a crane might exist at the location for a long period of time after an incident like this, this was at a residence, and the crane was operating in a public right-of-way. It was not in a situation where it could just exist there as it was staged during the time of the incident, until Mr. Turcow can have a chance to look at it. So in other words, nothing would have been different. They would have relied upon the investigative file of the Yates County Sheriff's Department, as he ultimately did, he would have relied upon additional materials generated by the Federal Department of Labor under their OSHA investigation. There's been some suggestion or innuendo or speculation that somehow the fatality of the decedent was brought about by the fault of Mr. Hange. However, there is nothing in the record actually alleging this, let alone demonstrating it. Nothing in the police report indicates that Mr. Hange was responsible. In fact, the police report itself acknowledges that there was an equipment issue involving the decedent. Nothing in Mr. Turcow's investigative findings make allegations of fault on the part of Mr. Hange. There's the inclusion of certain OSHA documents, the relevance of which has not even been established, and the source of which has not been confirmed in terms of whether it was a result of an adjudicative finding or any actual findings of fact. In other words, before the board is the allegation of one regulatory violation, and that one regulatory violation is the failure to timely report. And that is a violation that Mr. Hange admits. However, this violation, this failure to report is not the typical failure to report. It is a situation in which you had a family member who was deceased on a Friday. It was not a coworker who he had a limited relationship with. This was somebody very close to him and his family, because it was family. The furthest thing from his mind was following administrative procedures. He had to take the time to grieve the loss of a loved one, which it's difficult for any of us to put ourselves in those shoes. In any event, even if he had complied with the obligation by landing back on his feet just the following Monday after a weekend of grief, the outcome of this investigation would have been no different. The Department of Labor has not been harmed, has not been prejudiced. Instead, he would have reported it, that Monday. Everything would have otherwise been the same. The only difference is we wouldn't be here today. And the only reason why we were here today was because Mr. Turcow found one violation, and it's a technical violation of a failure to report that would have not otherwise changed anything. For that reason, we request that as the board considers whether to suspend or revoke or otherwise discipline Mr. Hange, it refused to do so. Mr. Hange has had a crane operator's license since 2019. It was renewed after it expired in 2022. He has had no incidents before this May 13, 2022 reporting issue, and he's had no incidents since. Clearly, he is competent. This is his livelihood. He comes from a family of crane operators. To suspend, revoke, or otherwise discipline him under these facts, under the technicality of a failure to report, would be a punishment far greater than justified, particularly when he has already suffered in having to have lost a loved one. I thank you everyone for their time today, and I appreciate your consideration of this matter.
Thank you, Mr. Fluvio. So now both parties have rested their case. What is going to happen is we are going to go off the record, and the Board of Examiners will review the evidence and deliberate. So if we want to reconvene at 1:45, would that be appropriate for the board? That's about 35 minutes. If we need longer, we can take longer, but
That's
okay.
So deliberation in the board.
Yep. So we will go. Hopefully you guys can see me. Sorry. Hopefully that won't happen again, but so we will go off the record, but the board deliberations do need to occur within the open meeting, so it will be continued to be recorded.
Off the record
So I
at
guess-
1:12 PM.
Right, so again, ask the parties just come back at 1:45. And if they need longer, we'll take over.
Thank you.
Thank you.
And just for point of clarity, the parties can, as members of the public, still listen to the deliberations, but you won't be permitted to speak or, ask any questions or engage with the board members while they deliberate. I also ask that since we're just doing the board members at this point, and it seems like the Department of Labor were having some bandwidth issues, if anybody who is not, anybody other than the board members could turn off their videos, so we can. Okay, thank you. If that helps. Yeah.
Okay, White Plains and Syracuse, go ahead and unmute and we can open our discussion.
We're unmuted. Can you hear us okay?
I hear
We
you
hear
now.
you, okay.
Okay. Obviously, it seems like the violation is what it is. I mean, it's not gonna change the outcome. My question is, where was he attached to the ball? Does anybody know? I mean, he had rigging, from what I read there, it sounds like somebody, he heard a click, it was mechanical and then he fell. I don't know.
That's pretty much all we have to go. I guess my question, everybody is, why wasn't there double connection? Because usually anytime you're hoisting personnel, it's required to be a double connection.
Right.
You know that, it's not part. Vince, what's the charge for? For not reporting?
He was issued a violation for not reporting, which is a violation of Code Rule 61. As you guys know, we don't have operational code rules regarding crane operations because they were preempted by OSHA. So Code Rule 23 is not something we actively enforce. But this board still makes kind of a justification to the competence and ability of the operator. So it's coming before you guys or before us for two reasons. One, he was issued a notification for failure to report. And, we generally investigate these within 24 hours, being notified. And the fact that we weren't notified, or the DOL wasn't notified for a week, hindered our ability to investigate this, but also for the board to look into and make a determination if we still consider him competent enough to operate that.
So that's the question before us is, do we feel that he was competent? And did his errors lead to the death of this person?
Did his errors lead to the incident, but also did we want to otherwise punish him for failure to report?
Hey, Vince, if I can ask, I mean, not that it matters now, but at the scene of the accident, was he tested? Not that it matters. I'm just curious as to protocol. I know what happens on a site, on construction jobs, if there's an accident, the person is tested.
The only information we have is what was in the police report, and the OSHA report that we got. We were not on site day of or immediately following the accident, or no DOL was on site or immediately.
Is testing a part of the code rule?
No, it is.
Do you know that if that ANSI, which is not written by arbitrator people, I mean, that's a regular, high-class organization, test bolts, I mean, all kinds of stuff. Is that accepted by OSHA?
do not know the procedure, if the procedure in the arborist manual is acceptable to OSHA. I only know what OSHA would have put in their report. So let's take a look and see what they said.
Well, but the OSHA report is to the, I mean, that's like getting a speeding ticket. Doesn't mean you're gonna be guilty of it.
Yeah, I don't know what OSHA's finding exactly is. If we could try to find it in here.
And I think they mentioned there was another document, I don't know if it was a plea deal or what, but that was not, part of the record or public. But that being said, Vince, I guess my concern is, we've always, stated that if you pick something, you own it. And that means that you're certifying that that pick to be safe, the rigging to be safe, and what you're doing puts, the load, the crane, in a safe position, whatever. In this arborist issue where you've got the arbor is saying that apparently the arborist that's getting on the hook you don't have to look at the rigging, you don't have to look at anything, and you just pull the lever. Is he absolved under that language from responsibility? Because if not, it's an easy one, and he should have been responsible.
This board makes a determination as to competence. He certainly could be following any standard procedure or best operating procedure, and we could find him still not competent by virtue of the fact that we believe he should have secured the load, or we can say he was doing all he could by talking to the arborist and asking him if his both tail lines are secure. I think that's kind of, we have to make a determination if following the procedure in this manual is sufficient in New York for issuance.
Well, I guess the part I'm having trouble with is it's stated in the investigation that he couldn't, or he didn't see the rigging, and he picked the individual up and just heard the click, but that the person fell right in front of the crane. Well, if it fell in front of the crane, then he must have hooked his own rigging on right in front of the crane, but it doesn't say the operator, approved the connection, made sure there was a double connection, and it was right in front of him where he landed. We don't understand, the investigation.
Well, I don't think we know exactly where he picked him either. Just because he fell in front of where he picked him from.
No, it just said he hoisted him straight up 50, 60 feet. It didn't say he boomed over or did anything different, because we don't understand the communication. What communication was, other than he said to pick me up, and then the operator heard a click.
Yeah, and John, excuse me, on that note, I'm looking at page 37, so there's rigging equipment there. It looks like the rope is frayed, but obviously in a couple spots, but it's not broken, but I'm just thinking, yeah, I would have to agree with you in that I think it is the crane operator's duty to inspect the load before he hoists, right, to make sure.
Well, I agree, Jeff, but in the past, at least, we've always maintained that it was the operator's responsibility. If somebody else is responsible, Vince, that's what I'm struggling with, is if we're gonna say that you can pick people, and whether it's an arborist or anybody else, are you responsible for how they connect themselves or not? Because I know OSHA mandates you use a man lift if possible. You would use a man basket if possible, which also has double. So I guess my question is, are we at least laying responsibility at the feet of this operator?
Well, yeah, that's the other thing. I mean, would a man cage have been, I don't know, in this instance, I mean, so that,
I don't know either.
I
John
guess
had
you
to
get,
come through there.
yeah.
Well, the thing was.
I mean, we're of the opinion that an operator can certainly refuse to pick any load, even if it's an individual that he doesn't feel is secured in an acceptable manner. We do not know exactly what happened in this instance because we were not on site or DOL was not on site to inspect it while the material was still on site.
Yeah, I think the only
You guys
one,
have operated cranes. I've never operated a crane, so in your opinion, would it be the obligation of the operator to secure, to make sure that if they were lifting an individual, that the load was properly secured, in this case, the load being Joe?
I don't know, you can just say, because before I walked in this room, I would have said that if he was not in a man basket in construction, our wiring can't hook onto the ball. Obviously, the same thing, which isn't just a guideline by an association, calls it out and tells you what to do, and apparently it's allowed by OSHA, which before I walked in here today, I would never even guessed it was. I don't know what, I mean, they apparently had a public hearing about it and things like that, so, I don't know. And I don't know exactly any more technical than what's shown here. So that's why I wondered if the Department of Labor had talked to OSHA, and is it a common practice?
I can tell you that although I am a Department of Labor employee, information about these cases are specifically shielded from me because I am a board member. So the only thing I know about the Department of Labor's investigation is well.
I can understand his counsel not wanting to interview his client, but I mean, he's really the only one that can answer the questions and that knows what happened. I mean, so when he hoisted him, did he actually see him fall? I don't know.
Yeah,
I don't know either.
Gentlemen, can I intervene for a second? I just want to say that, listening to what you're talking about now, when we're talking about culpability, which is outside of the scope, this is really just a failure to report, not whose fault it was. So I just want to, that's the violation we have. I understand what you're talking about, but I just want to just throw that out there. And I don't mean to intervene. I know that you guys are the board, but I just want to make sure that.
The examining board will be, the examining board has to determine not only whether they violated a regulation, but also if they're a person of sufficient competence to retain it.
Yeah.
So, although culpability for this specific accident may not be able to be straightforward determination, if we feel that this individual did not properly inspect his load before it was lifted, that goes to his competences.
I just wanted to make sure that, if we didn't go outside the scope of what violations, what we were here for today. And as I said, this is my first crane board hearing, so I don't want to interrupt, I don't want to interject, but I just want to throw that out there. Just as, playing devil's advocate here, and if I'm wrong, then that's completely fine, but I just want to make sure that, it is inside the scope of what we're here today, but you guys know better than I do, so you can continue.
I mean, I don't know enough about the ANSI thing. First I ever heard of it before today. As far as securing the load, did the guy have two lines on when he went up? If that's allowed, did he unhook one? It talks about you can unhook from the ball to get in the tree. So if you did that and fell, that's not the crane operator. I mean, as far as failure to report, he obviously failed to report.
No, and if that's all that we're discussing is failure to report, I guess he failed to report. I don't know what the past practice is for discipline on that, and I don't know if that's side or if someone else decides that, Vince.
It's for us to decide if we want to take action against his certificate for either his competence or for his violation of the regulation.
Us being us, the board, or us, the Department of Labor?
If in looking at the information in front of us, we determine we don't want to question his competence regarding his operation of the crane on that day, we could still take action on his failure to report, either a suspension or a revocation or other restriction.
1 month.
We don't get a lot of these, so I can't say specifically if we've taken action previously on failure to report. I do know on the last hearing we had, which was several years ago, failure to report was one of the violations, was also the main violations. And we took action on that one.
What did we do?
We revoked his license.
In that case, we revoked his license, but the situation was not similar to here. In that situation was on a construction site.
Oh, I guess I could.
Well, as per the judge's instructions, I mean, technically, we're here to decide just on that one issue. I mean, but one ties into the other, so I don't know. As far as his competence,
I just wanna, and this is Laura Campion. And unlike Mr. Zablo, who's representing the department, I'm here for, in the capacity of providing counsel to the board. Although he and I both report up to the general counsel. And so I just want to clarify that, you all have the decision to make about what you have in the record in front of you. Tracy is here as somebody to assist in operating the hearing and making sure that, everything's on the record and everybody's due process rights are met. But the decision lies with you. You have the information before the record. So, I just don't want you to think Tracy's the judge and that you guys are beholden to her as a jury. It's really, you guys are the judge.
Yeah, I'm here strictly procedurally, but
Well, then what we've got in front of us, at least me and John are sitting here talking too. We certainly feel that discipline is in order. Jeff, do you think 1 month, 6 months, if we do a suspension, at least it's a message. We don't feel he was responsible. He certainly didn't see that there was double connection as far as we can tell. Andy reported it late, and it was an extremely serious situation that should have been reported. So
no, I concur. I think anything less than like a year would just be too lenient, but that's something we'll decide on.
6 months, we do 6 months.
We go 6 maybe, but then.
And that, at least he's on the record for having a suspension, Vince, and if there's any more safety issues, he's already got priors, correct?
Yes, we would review all of the information when he does come up for renewal, including if we issue some kind of discipline such as a suspension. I am of the agreement that the failure to report is significant. It certainly hampers the Department of Labor's or reporting alert, certainly hampers the Department of Labor's ability to investigate these situations. And he did technically have till Monday, but if he had reported it on Friday, our inspectors go out 24/7 to investigate these incidents. So they would have been out there the same day if it had been reported. So I'm in agreement that there should be at least some kind of decision for failure to report.
And these were extenuating circumstances, right? I mean, I can understand him not even thinking of the day of the accident, especially if it was a relative, and even that following Monday. I mean, maybe, I don't know. I'll give him the benefit of the doubt there, but he's still on the hook for reporting it.
Still, just for the sake of everybody's knowledge, Vince, if this complaint had been written differently, we'd be having a different discussion. If it was more than a late notice, it should have been, a possibility of all improper error by the crane operator, something into the complaint that could have let the crane board look at the entire record.
I can tell you that the narrative and the addendum that DOL inspectors submit is generally the record in crane accidents, because violations are only issued through Code Rule 61, not through Code Rule 23. So it could very well be, even if he had reported it on time,
we, and we did find, or DOL did find that it was operator error. There may not necessarily have been any violation that we could have written, because like I said, the operation of cranes is preempted by OSHA. It's only the competence of the operator that falls under,
Yeah, but
or the certification and competence of the operator that falls.
my point is, had the complaint or the charge sent to him said, and any other violations found by the crane board, it would at least let the crane board have a say. We're getting handed something, at least in my opinion, that doesn't allow us to look at,
We're looking at one thing.
we're looking at a whole voluminous record of things that'll possibly this could have led to, but we're dealing with a timeliness issue. And I'm just saying that for future reference.
Well, certainly,
If I can
go ahead, Jeff.
Sorry, Vince. Yeah, but this Wilcox Crane Company, I mean, do they have a history of, not that it matters in this case, but have they been cited with any violations for equipment, problems and?
They've had other violations. I don't know if it's the same person, but that's not what this hearing's for.
No, right.
So,
Yeah,
In the future, we can certainly re-review the way the department investigates these situations. But because there are probably, it's not my area of expertise, but there's probably legal reasons why certain information can't be brought before the board until they're in an open meeting setting. But we can look into that going forward, what information the board can get ahead of time.
well,
we're not even ahead of time, right? That's not what you're asking for.
No, I'm just saying, when they send out the complaint that this person receives, have something in there that it's the timeliness issue and whatever the crane board feels is appropriate as well. Just something that allows us to review all the information. And because we may find other violations that aren't included.
Yeah, we have no way of knowing. We have no idea.
Go ahead, John.
I was just gonna say, we have no way of knowing if there was 2 lines or not 2 lines, if he unhooked or what he did on the hook. To me, it would have been pretty clear cut that you can't ride a ball. But with this ANSI thing, which is not just by an association, I mean, ANSI even writes up how many, the kind of bolts we put in structural steel. So, it's American Institute. And, I don't know how without more we can do anything more than that. One thing I wonder, Vincent, is when we mail the guys a license, is there anything in there like a handbook or that tells the guys? I'll bet you there's a lot of people that don't know what the reporting are.
There is nothing we mail them. However, in the application procedure, they're supposed to be knowledgeable of Code Rule 61. And they're told they will be, as part of the written exam, tested on the requirements of Code Rule 61. We do, like I said, in the application procedure, tell them they have to have read and understand the Code Rule.
Oh, yeah. They ain't gonna look Code Rule 51. I could have been.
That being said, like Don's talking about with this ANSI thing, can the department, can DOL attorneys check and see if ANSI has any standing in OSHA, or because we defer to OSHA, and certainly we want to know if that document has any standing for, because I'm sure that, you've certainly seen a number of tree companies that are in violation numerous times. And if this is this big of an issue, we should be reviewing a little deeper.
Well, we should know if you can hook onto the load line.
Oh, yeah, no, that's what I mean. We need to know.
Does OSHA accept this?
Is that a law or a standard, or is that just a guidance thing from ANSI?
That's it. I bet you ANSI is just the guidance, but does OSHA accept it? Because generally when you have a public hearing like that with a different guideline, either they accept it or they don't. But if we're gonna just enforce OSHA, or, yeah, I mean, we should know.
For the future, we should know, but I think the situation here, I think we're in pretty good agreement that the discipline's in order, and I would move to, discipline by suspension of 6 months.
Okay, so let's kind of go through it here. So Terry's recommending a suspension of 6 months. Is there general agreement on that?
I would agree with
I
that.
think Terry-
I'll agree
I
with
think Terry moved.
Okay,
for,
yes.
suspension.
The rules of order. Terry moved for a suspension of 6 months. Does somebody second that?
I will.
Okay, and then we'll do a vote on 6 months suspension as the action we'd like to recommend in this case. So I guess I'll do a roll vote. Terry,
I,
John,
Yes.
Jeff,
Yes.
and I'm a yes as well. So our recommendation in this case is a 6 months suspension.
And Vince, can I suggest something? Only because he's worked for this company a long time. Just forewarn him that in the event he's found operating a crane again, he can never get his New York State license, because we know how some contractors are slippery, right?
We as part of the I think decision, there will be some kind of statement to the effect that he cannot operate a crane, during the period of his suspension within the jurisdiction.
Okay.
appropriate.
I think we're in agreement there. Tracy, should we just wait now till 1:45 and everybody comes back?
Yeah, we might as well. I mean, if you see people popping on, they might know where they were listening. So, I guess we'll just wait to see who pops back on.
Yeah.
And Vince, are you going to be the one to
Yeah,
report this?
I'll report it.
I got this. But I'll bet you I can take you. You're gonna bring 100 of them in here. Half my interferes. So one you have to. Yeah, but you a lot of them don't know. Bet you, we tell all our guys, and I'm sure there's a bunch that don't know. We tell them all. You call the ambulance, you call the sheriffs, anything that goes in an investigation, you better be notified the state in any fashion possible. Wait when the state police come. You can. Well, you'd think they were the same agency. And no, I tell everybody, I said, if you hit something, something's damaged, there's any kind of, I don't care if it's $250. I don't care if the limit's 500 or 1,000. They call them anyway.
Mrs. Meeks, would you
Yes.
mind? I'm sorry, I'm not interrupting, am I?
You are absolutely not.
Okay, I just wondered if I could do a little housekeeping here before we go on with the record. That way we don't have to do it at the end, if you wouldn't mind.
Please do.
Okay, I just need to confirm some names for the board members. I have Terry Holman. How is that spelled, last name?
Hogle, H-O-G-L-E.
Oh, I'm sorry. H-O-L.
G-L-E.
Okay, sorry about that. Okay. And then Vincent, I'm sorry, you are a board member as well?
Yes.
Okay. And then who else do we have for board members?
John Dillon.
John Dillon.
And how do you spell your last name, John?
Dillon.
Okay. Anyone else?
Are you muted, Jeff?
Oh,
You got to unmute you, yeah, Jeff. Okay, it's Jeff.
Yes,
Jeff, how do you spell your last name?
Louglin, as in Nancy. That's my wife's name.
Okay.
I didn't get her.
Okay, and then the deceased Ryan Rector, how do you spell his last name?
Based on, I think it was R-E-C-T-O-R.
That's correct.
Okay,
RECTOR.
okay, that's.
I'm
what I
sorry,
had.
I didn't send you the board members' names and everybody's names.
No, that's okay. This works just fine.
Yep,
And I-
RECTOR.
Okay, great. And I think that's actually all I had. Thank
Oh,
you.
perfect. Thanks so much.
You're welcome.
Just look the record. What do you call it? Stenographer. And the other name though. Must be. If you bought the whole thing, then you were right from here to beer 30.
Okay, I'm there. Except for today's Thursday, I'll have to hunt him down.
Oh, yeah. Bet you won't have to hunt too hard.
Yeah.
How's he doing? How's his wife doing? Didn't he say his wife wasn't doing good? Or-
She has something like arthritis, rheumatoid arthritis.
Oh, really?
But his daughter sleep in the
house.
form of cancer. Everything's
Everything's good. Good.
yeah, he's a beauty.
Understand.
He's got a 70-ton rough terrain crane. He just rented for a place to put a log cabin that was built in Oregon back together in Old Forge. Oh, they got to paint it in 2 months.
Really?
Yeah, this place is like,
The kid, oh, yeah.
he said, yeah, I live in the boathouse, John.
Yeah. Probably, he's probably one of that himself.
No, he's got a guy up there.
Does he?
Well, they must have a road all the way around it. He's like,
Yeah.
we'll go up someday.
Went into.
Hey, John,
Yeah.
I'll be up your way at the end of September up Indian Lake.
Oh, yeah?
Yep, there goes the neighborhood.
Luckily, I don't go over there much. In Constantia?
No, I'm not making that trip.
Oh,
Probably got a better trip.
better offer.
Got a better offer.
No, it's not much could be better than spending a weekend with the guys.
How about home?
Yeah.
What?
I actually separate with my stuff. I always in retirement, sorry to get to. So.
Guess we won't know. But
It's the 24th, I think.
24th. November, September.
It's just called like that.
Yeah.
Every 2 weeks. And then you get to go to Long Island.
No, actually, I couldn't anyway.
No.
We've got 3 weddings this fall. It's like, well, I usually when I get some work done at the camp because I don't get it in the summer. Jesus, more to do.
Are they gonna be at camp?
No, I had one there, that's it.
You got a couple of friends that they're doing those camps, or doing those weddings up on Panther Mountain. What's his name from Star Lake? Langevin.
Oh,
You
yeah.
know him?
No, I don't
He's-
know.
He's got been nailed so many times for everything, EPA violations and prevailing rate violations. He built this
Like Langevin.
Langevin.
Yeah.
He's a site contractor up there, Star Lake. and
Oh, I've heard the name.
He did some work over at the Ranger School up there. Yeah, my name's a dirty. I shot up, saw him doing it. I said, good thing. I said, oh, I said, good thing. I'll have
We could hear them.
right as a pig. Well, he got tagged. His guys like me. He don't.
Yeah. I understand these guys. It's just,
Rolling.
Yeah.
They'll never catch me up here in Wanakina. But yeah, I said a thing for Rob McGregor. He sent me over there. They're doing docks up there by Lake Placid. No, it was Saranac. The Saranac. They're pulling there, and I'm just like, you could have drove 2 trains in this track. What is this place? What a man.
yeah.
Like, oh my. And the dock show up one trailer after another. And I'm like, what's he got putting in a bridge across the lake? Wow. Nice docks. Oh, yeah.
Yeah, I didn't know it, but before we'd even been there, that they'd had somebody out on the lake and drove the duck piles.
Oh, yeah. Oh,
I think it was that one, in Buffalo. Fargo.
oh, from,
They do a lot of ducks.
yeah, a lot of, they do a lot of business. Yeah, I knew George. George is gone now.
Yeah. I heard
He
that.
was a good guy.
Yep.
Yeah,
Over family is
like his bookkeeper. I don't know if his partner or office guy, but he's got scammed for a lot. I wasn't sure if he was gonna make it, but then he come back with pretty much vengeance, but now it's.
Oh, he sold the company? I thought he had a relative that was gonna be.
Well, maybe, but he's out.
He's out. Yeah, he was looking to get out. 5, 6, 7 years ago. He's just getting sick of it. It's probably.
I see Mr. Fulvio was back. Mr. Zablo, are you back?
Yes, in fact, I never left.
Oh, okay. There we go. I was waiting for everyone to pop back on. Okay, we can go back on the record.
On the record, the time is 1:49 PM.
Okay, great. Crane Board, have you made a determination in the matter of the suspension revocation restriction for Crane Operator Certificate of Competence relative to Trevor Hangy, Crane Certificate number 19-0038?
Yes, we discussed the matter and by unanimous decision, we are recommending a 6-month suspension of his crane certificate.
Okay, thank you. So, Mr. Hangy, you do have the right to appeal if you so choose to. If you don't have a problem with the determination, then whatever terms or conditions exist, you will have to comply with. So is there anything further from anyone else?
Your Honor, if I may just ask for clarification purposes, our understanding that the basis for the suspension is the failure to report. We would just like that confirmed in the decision.
I'll pass it over to the Crane Board.
I believe we were in agreement that there should be punishment for the violation for failure to report, and that is the main reason for, that is the primary reason for this. I don't know if I should speak for the entire board here, but I believe the board did not have enough information to come to a determination that Mr. Haney failed to operate competently on that day, but we did definitely come to a conclusion that he failed to report in a proper time, hindering the department's ability to investigate.
Thank you.
All right, if there is nothing further, then at this point, the hearing is concluded. The order and determination will go out. I don't know, I will get the specifics on if I create the order of determination of council's office, but we don't need to worry about that now.
But I want to thank you all very much for being here and participating. And if parties would like transcripts, they can make arrangements with the court report. So if there's nothing further, I thank everybody and we can go off the record.
Off the record, the time is 1:51 PM.
Thank you.
Okay, and I have
Thanks,
one more
everybody.
piece of business, just to close the public meeting here. Now that the hearing is over, I make a motion to close the Crane Board meeting. Does anyone second?
Second.
Okay, this meeting of the Crane Board is closed.
All right, thank you, everyone.
Thank you.
Thank you.